you know when they're talking to you, okay? Okay.
The court is in session in cause number 330460. The case is styled the state of Texas versus Leela Lorraine Daigle. We have Miss Leela Lorraine Daigle, who is appearing via Zoom. Now, Miss Perazo, you represented Miss Daigle in this case, is that correct?
Yes, sir.
Now, Ms. Peraza, do you waive a record in this case?
We do, Your Honor.
Okay. Ms. Peraza, I have before me a motion to reduce the bond that was filed in cause number 330460, and the case is styled the state of Texas versus Leela Daigle. Now, Ms. Peraza, you have filed this motion. You're the movement. Are you ready to go forward?
Yes, Your Honor.
Okay, you may go forward.
Okay, Your Honor, Ms. Daigle's bond is currently set at $750 on the current case. Ms. Daigle has insufficient funds to meet that bond. Prior to Ms. Daigle being apprehended and taken into custody at the last court hearing, Ms. Daigle had been out. She appeared for all of her court hearings. She's never missed a court hearing, to the best of my knowledge. She also had been complying with whatever conditions had been set previously and was unaware that a warrant had been issued for her arrest. I apologize. Somebody was trying to call in. She does not pose a flight risk. I would like to ask Ms. Daigle some questions just so we can get her, so I can get some testimony from her concerning the ties that she has with the community and what her abilities would be if she were able to make bond.
Okay, Ms. Daigle, would you please raise your right hand?
Yes, sir.
Ms. Daigle, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir, I do.
Okay, Ms. Daigle, you may put your hand down. Ms. Peraza, you may go forward.
Thank you, Your Honor. Ms. Daigle, you've kind of heard some of the things that I was just telling the court. Let's talk about your ties to the community that you have. Do you have any family members that reside in Jefferson County?
Not at this time. No, ma'am.
Okay. Where were you living before you were arrested?
Well, it was at my cousin's, but it wasn't a permanent residence.
Okay, and where does your cousin?
The ties, it was a place where I received mail. No,
Okay.
no family ties.
But you were residing there, correct?
No, ma'am. I was getting my mail there.
Okay. Well, where were you residing was my question.
In a trailer park in Port Arthur.
And who did you live by yourself?
Yes,
or
ma'am.
with your, okay. And you said that you had stayed with your cousin some before you were taken into custody?
No, ma'am. I was receiving my mail there.
Okay, but okay.
But
So you
since
do
then,
have,
they've moved. So I'm not even really sure where they're at now.
okay. So if the court were to release you today, would you have a place to go to?
I would find a place to rent. I would have to.
Okay, so right now you don't have anywhere to go.
I would have to find another place
Okay.
because I was taken in. So yes, ma'am, I would have to find another place.
Okay. Do you have any way of posting bond if the court were to lower your bond from $750?
Yes, ma'am. I have $350.
Okay. And is that there at
Cash.
the county jail?
Yes, ma'am.
Okay. Why haven't you attempted to post your bail on the $750?
Because whenever I tried to get a bondsman, but they said that they would not do that unless I paid them the whole amount. And I don't have it.
The $750?
Yes, ma'am.
Okay. What company did you talk to?
One of them was the A1, and then the other one, I'm not sure what that one is called, but somebody in here told me that it's across the way from this facility.
Okay.
So I called 2 different places, and they told me that they could not do that because they wanted the whole amount cash.
Okay. So one of the problems that the court is going to have is getting notice to you for your future court appearances. So how would the court notify you of your next court date if you
By
don't have
phone?
anywhere to?
By phone.
Okay, so right now there is no address for the court to send documentation to, or any bond company should they decide to take on your bond. Is that correct?
Ma'am, do what now? If there's no place to, one more time with that, please. I'm not understanding that.
Is there any, see, there is no address that the court or a bonding company could, or me for that matter, would be able to send you notice of a hearing by mail. Is that correct?
Correct.
Okay.
There was at one time, but nothing was ever sent to me.
Okay. And do you have any kind of income besides the $350 that is at your disposal? In other words, how do you intend on making money?
I would have to get another job.
Okay. Do you have a vehicle?
No, ma'am.
Okay. Did you have a vehicle prior to your last court date?
No, ma'am.
Okay.
I'll have to get somebody to come and get me. I'll have to work things out. I've been trying to work things out, but every time I do, something or another else, it seems that I've been gone around, you know, like they were supposed to send me something in the mail for me to appear in court, or nothing was ever sent to me. Then that's how a warrant was sent out for my arrest, because nothing was ever sent to me.
And you do have a phone? Did I hear you say?
I have a phone. I'm gonna have to get it hooked back up again because it's out now, because I have been incarcerated for 45 days now, because I was not aware of a warrant being sent out for my arrest. It's kind of hard to take care of things whenever no type of notice is sent to you.
So the notice was the notice of the court date. How did you get notice of your last court date that you appeared
They
for?
sent out a warrant for my arrest.
No, Ms. Daigle, what I'm asking is you appeared in court and you weren't aware that there was a warrant until you came to court. So my question is, how were you aware of that court date that you came to?
From the last time, whenever they sent out a warrant for my arrest, and then I bonded out, and they
I
gave me the court date, and I was at that court date.
I see.
And then another warrant was sent out from something else that was afterwards. I believe that was afterwards. They were like mixed up instead of, they weren't in the correct order. And I never was sent any type of notification. And they also had a phone number for me at that time. They never once called me whenever I tried to call them. They told me that there was no such a case, that did not exist, that there was no such a case. And so therefore there was no court date.
Okay.
I tried to take care of that other one last year on December the 4th, after receiving it in November.
I see. All right, Your Honor, I pass the witness.
The state doesn't have any questions, Your Honor.
Okay. Ms. Peraza, you have any other witnesses?
No, Your Honor.
Okay, hold on a minute.
Yes.
Ms. Peraza,
Yes, sir.
I was just trying to get ascertain some more information. Now, your client stated that her bond, which is at $750, she contacted a bonding company by the name of A1, and the bonds, and that company told her that because her bond is at $750, she had to pay them $750 cash.
Yes, sir.
That's what she said, Your Honor.
Okay, now typically, I know the bail bonds board, I think the bondsman only required to take like 10%, which would have been $75 of the $750 bond. And
Yes.
and she's saying that they asked her to pay the full amount of a bond on a shirt.
That's what she said.
Or I had to have someone from outside that was over the age of 21 to do it for me.
Oh, so she didn't have no co-signer? Was that the problem?
Yes, sir.
So she's saying she didn't have a co-signer, is that correct?
Yes, sir.
Okay. Now, and just listening to the testimony, in reference to her work record, currently she's not working, is that correct?
I don't
That's
have a
correct,
job.
Your Honor.
And
was.
I understand now, and her family and community ties, basically she had family here, but she no longer have family here, is that correct?
That's correct. Apparently they moved.
All right, and she, at one time, prior to being incarcerated, was living in a trailer park in Port Arthur, is that correct?
Yes, sir.
All right, now, she currently has 2 pending DWI cases, is that correct?
Yes, sir.
Now, one of the cases, I guess, she has a bond on one of the cases. And the other case is the case that, well, she has a bond on this one, but on this case, she's asking for the bond to be reduced. Is that correct?
That's correct, because I believe that was the one that she was arrested on.
Okay, and I see the previous case, the original case, she has a cash bond on that, on cause number. Okay.
Yes.
In call
Sorry.
512, she has a cash bond on that case. Is that correct?
Yes, sir.
What is that cash bond amount? $750. And that cash bond amount on that case is $750. Is that
Yes,
correct?
sir.
Okay. And so
That's how I was able to get a court date.
now in reference to her previous, do we have any information on whether or not she's had some previous bond forfeitures? The Miss Maxey, do we know whether or not she had some previous bond forfeitures? The court is trying to determine whether or not she has conformed with previous bond conditions.
Not to my knowledge, Judge.
Okay, and so do you have any other outstanding bonds other than the $750 bond, the cash bond that you're currently on? Do you have any other bonds in any other cases?
No, sir.
Okay. Is there any, Ms. Maxey, do you know of any aggravating circumstances in these DWI cases?
It doesn't look like there are any that
Okay.
I see.
I'm looking now in clause number 330460, the case that she's asking for a bond to be reduced in. I have a probable cause affidavit. The court is going to take judicial notice of that probable cause affidavit. And it alleges that there was a major accident. Do you see that? In
I'm pulling that.
Cause number 330460, it alleges that there was a major accident as part of the facts in this case.
Okay, yes, sir, I do see that. And also it's a DWI with an open container.
Right, which makes it a minimum of 6 days. Okay. Now, Miss Daigle, did you talk to any other bonds? How many bonding companies did you talk to?
2.
2, okay. And so basically, I think, Ms. Daigle, from what I'm hearing, you did not have anybody who would co-sign on the bond. Is that correct?
No, sir, I did not. I don't.
Okay.
No, sir.
Well, let me ask you this. Now you have 2 DWIs that's pending or that is alleged, and the court, even if the court reduced the bond, or if you get out on bond, the court is going to give you some bond conditions requiring that you have an interlock device on any vehicle that you own or operate. Do you understand that?
Yes, sir.
Okay, so I think at this point you stated that you don't own a vehicle.
No, sir.
In that event, then the court may be, well, the court is inclined to order that you get what is called a scram device.
What's that?
That's like a portable interlock. It's a portable device where individuals, well, it would detect drugs or alcohol in your system.
Okay.
Okay. So
Nice.
that's one of the things that the court has to do in terms of setting bonds. The court has to consider the future safety of not only the victim, but also the community. And so looking at the facts of this case, one, this case having a major accident, and two, that this is your second DWI that you have pending, the court has to consider and will consider the safety of the community before any bonds are given or even reduced. Okay, so my question, I know there's a fee for the scram device, and I know you said that you have about $350 cash that's on what we call your books, that you have in your account at jail. Is that correct?
Yes, sir.
Okay. Now let me ask you this here. Now you said that you had one cousin that at one time that you was getting your mail from.
Yes, sir.
But that cousin has since moved,
Yes,
and you
sir.
don't know where that cousin is located. Is that correct?
Correct.
And you don't have no other relatives
Family? No, sir. I
in the
don't.
Jefferson County area?
No, sir.
Okay, now where are you actually from? Are you from this area, or are you from another state or another county?
I have lived in Texas for more than 30 years.
Okay.
Okay.
And basically you lived in different towns in Texas?
No, actually, I lived in Port Arthur.
You've been living in Port Arthur? Okay.
Yes, sir.
Okay.
For more than 30 years.
Okay. Okay. Now,
And
Miss,
always worked and had a house, paying for it. I was
now,
married,
okay,
but I'm no longer married.
okay. Now, Miss Daigle, at one time you were getting your mail at an address 3980 12th Street in Port Arthur, Texas?
Correct.
And that was your cousin's address at that time. Is that correct?
Yes, sir.
That's currently where Rayla's sending the notices of the court date to, because that was the address on the bond. So if that's changed, she'll need to notify Rayla and pre-trial.
Okay. So is there, so you don't have, if the court is inclined to, give you a bond, is there a way to, how are we going to be able to get in contact with you?
I am going to get me another phone, and that way y'all will be able to get in touch with me. That's what I had the last time, but I never really received any phone calls.
Oh, yeah, but
And I had an address at that time, but I never received any mail, any notices to let me know about anything. And when I tried to make phone calls,
that was now, let me ask you,
that was a year ago.
Okay, but that was before you was on this cash bond, is that correct?
Sir?
That was before you posted the cash bond
Correct.
of $750. But
Correct.
when you posted the cash bond of $750, do you gave the bond, you gave them your address at 3980 12th Street in Port Arthur? Is that correct?
Correct.
All right. Okay.
Yes, sir.
So okay. Now, typically when we have bond, Kate, when the individuals are let out on bond, we have to have some means of contact. And when I say contact, we're saying by mail. Or they have to have it's not by telephone, but by mail. It has to be a physical address so that, because notices are sent out by mail. Notices are not sent out by telephone.
Well, yes, sir. Whenever I had bonded out this last time, they told me that there should have been something sent to my address that I had, letting me know that I had a court date.
Okay, you're saying when you
But there
bonded
was
out,
not.
let me ask you
Nothing.
this. Now you said that when you bonded out the last time, and that was the time that you got the $750, right? That was the time that you paid.
Time before. We're talking
$750.
about two different things here, two different cases. The first case was whenever a vehicle, and this was in Port Neches.
Now, Miss Daigle, let me do this here.
Yes, sir.
I don't want you to go into the facts of the case. You have a right to self-incrimination. Anything that you say can and will be used against you in a court of law.
Okay.
I'm just trying to determine whether or not there is a way through mail that you can be notified. That's what I'm trying to
Not
determine.
at this time. I did have something, but I don't anymore.
Let me ask you this here. Now you talked about having a cousin in Port Arthur. Do you have any friends that you can receive mail at?
Yes, sir.
Okay. What about any former employers?
No, sir. Because the job I had, I don't even have it. I don't have it
Understand.
anymore because of the circumstances.
Now, let me ask you this here. Now, if you're let out on bond, do you think you may be able to get that job back?
Maybe. I'll have to check.
Okay.
But from all the lack of the things that I have not been able to do because of things according to the law were done around me, well, I'll do the best I can if you let me out.
I understand, but I'm trying to we're trying to find out if there's an address. Well, let me do this.
Your Honor, can I make a suggestion?
Okay.
The notices come to my office, and so maybe that would suffice for now until Ms. Dangle does get an address where we can send her mail. She said that because we were able to get in contact with her by her phone number, and she came into the office. We met with her. So I have a strong belief that she will make sure that her phone is in working order again, and that she knows to contact me if her number changes. Otherwise, there will be another warrant issued for her arrest for failure to appear if she doesn't keep in touch with me.
Okay. Now, State, do you have anything to add?
I don't think so, Your Honor. The state would just defer to whatever would please the court in this case. The state would just say this bond is already set pretty low. And just, it seems like the weight of the number of factors almost falls into evenly. So the state would just defer to the court on this.
Okay, but what I was actually looking at is one, the second DWI, if I'm not mistaken, the one that we're here on, which was filed second, actually occurred prior to the first case. Is that correct?
That's
Yes,
right,
sir.
Your Honor.
And so that case typically should have been filed first. And I would imagine there may have been some issues with the lab, or that's the only thing I can figure out. It just, but I know that you have that statute of limitations is 2 years, and so they had 2 years in which to file it. But it's just that when she did have the other case that was filed, the second case was filed first, even though she had another case out there that hadn't been filed. And then after she get on bond on the second case, the new case, well, the earlier case is then filed, and then she's arrested on that new case.
That's right.
And I think from looking at some of the testimony here, it looks like she does have money to make a surety bond. However, because she does not have nobody to co-sign on the bond, no bonding company is going to be willing to give her a bond without, I guess, having some way of them having a co-signer to secure the money that, well, the liability really, because they'll be on, their liability will be $750. If they let her out on $75, they need a way to, if she forfeit the bond, to collect the $750 from either her or co-signer. So I guess that's the dilemma that they have with, or the dilemma she has with finding a bonding company that is willing to get on her bond. Even though she has the money to make a surety bond, she can't make a surety bond because she doesn't have a co-signer to get on the bond.
Yes, sir.
So ordinarily, she probably would have been out of jail had she had either a relative or a friend or somebody to get on her bond. Now, so what the court at this time, I'm gonna take this matter under advisement, and I'll get back with my decision with the state and Ms. Perazo. But at this time, the court is going to take this matter under advisement.
Yes, sir.
And I'll also be considering all of the statements that was made today. And also I will also consider the arguments that have been made by the defense, as well as the state deferring it to the court. So at this time, the court is going to take this matter under advisement, and we'll be in recess until the court makes a decision, which was not going to be.
Your Honor.
All right, you're welcome. All right, so at this time, this hearing is over. Ms. Perazo, well, Ms. Daigle, please just stay in contact with your attorney, and your attorney is going to stay in contact with you regarding the decision that the court is going to make concerning your bond. But at the same time, the court would, if you still try to call some bondsmen to see whether or not there may be one who's willing. But at this time, the court is just going to take this matter under advisement. So at this time, this hearing is over. And everyone, Ms. Daigle, you have a blessed day. Ms. Maxey, you have a blessed day. And Ms. Perazo, you have a blessed day as well.
So I need to
Thank you,
find
Your
out-
Honor. You do as well.